Judge, I do not have a judgment on this case for you to sign today. Yes.
Mr. Carey, are you able to hear me okay? Looks like
I can hear you well.
There we go. Okay. Were you anticipating anybody appearing on this file today? I've got a couple other people that have connected. One is named Karen Barnes.
My two defendants are McAllister and McAllister.
Okay.
Karen Barnes is set at 2:30 for a divorce.
Oh, okay. Then I have, can you see the other people that have joined in? There's a gentleman here that's on a Google Pixel 8.
I believe that might be James Barnes. That might be Mr. Barnes.
All right, not on this case though.
Correct.
Okay.
At least to the best of my knowledge.
Okay, we'll go on the record then. Let's see here. We're on the record in Lagerstrom versus McAllister. This is case number 2311376. We have Mr. Carey connected on this file on behalf of the plaintiffs. We do have some other individuals connected, but they're not related to this case. Mr. Carey, this is your motion for entry of a default judgment today. In receipt of that motion, and I believe we did receive a separate order. Is there anything that you wanted to say in support of your motion today?
As little as possible. This is a action to quiet title. Service was obtained over all interested parties via alternate service by posting and publication. After publication was completed and the time frame for answering post-publication ran, we filed a default. A copy of the default against both named defendants hopefully resides in your file. And we are now moving for entry of a default judgment to quiet title. I'm hoping that yesterday we delivered that default judgment quieting title to your office.
Jen had it for me.
Oh, okay.
Yeah. Okay, so in reviewing the file, the court notes that the plaintiffs did properly serve pursuant to court rules. The defendants in this case, they did fail to file a timely answer or otherwise defend. The default was properly entered, and then the interested parties were provided with notice of the date and time of today's hearing. As I indicated previously for the record, that was set for 1:30. It's now 1:36. No one else has appeared on that. I'm aware that we did receive a copy of the proposed order, Mr. Carey, or judgment, so the court will sign that following today's hearing. And anything else that we need to address for the record today then?
No, I appreciate the court facilitating entry of judgment.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you, Judge.
Jen was just Okay, Mr. Gurmurthy, it looks like Mr. Jaskowski's signing on right now. There we go. Mr. Jaskowski, we could just have you unmute.
Should be good now, Your Honor.
Okay, great. Thank you. We're on the record now in Osum versus Scott, case number 118659. If I could have counsel put your appearances on, starting with plaintiff.
Thank you, Your Honor. Good afternoon. Ravi Gurmurthy appearing on behalf of the plaintiff, David Olson, P number 78368.
Richard Jaskowski, Your Honor, appearing on behalf of Jill Scott, who is present with me in my office as well. So.
Okay, great. And the record should reflect Mr. Olson is also connected by Zoom video. This is set for a status conference today. I'll leave it up to either counsel to jump in here and just kind of let me know where things are at and what we might need to do going forward.
Certainly, Your Honor. Counsel for the plaintiff, as you may be aware, is a new attorney that substituted in. Once he became involved in the case, we had communication. We thought we were going to reach a resolution of this matter. And then more recently, I guess I received information that it looks like we are not going to reach a settlement. So unfortunately, I think we should have a hearing scheduled. I would request in about 90 days. And if we could have discovery up until then, it will be necessary for me to take depositions of the plaintiff and his wife and get more financial records, things along those lines.
Okay, Mr. Gurmurthy?
That is correct, Judge. As the court's aware, this came back on remand from the Court of Appeals regarding the Social Security benefits. My understanding is since then, Ms. Scott has applied for benefits. She's receiving perhaps $1,500 a month in benefits that she's deriving based on her Social Security and Mr. Osum's benefits based on their marriage being longer than 10 years. So Mr. Jaskowski is right. We both need to do some financial discovery. I think the court's, your prior orders indicated that depending on what her benefits were and her incomes were, if it were over $1,000, that Mr. Osum's spousal obligation may end. And clearly that is the issue we need to navigate. And clearly the Court of Appeals issue that it came back on remand was that Social Security couldn't be split, but she could certainly derive the benefits, which she now is. So I think both counsels just need to work through the finances of where it is. And of course, as Mr. Jaskowski stated, my client's wife's income is not going to be an issue, but the benefits that he derives from her employment could be an issue. My client's wife, Shelley, is no longer working, so those issues have to be navigated. So I would think 60 days would be plenty, but I'll leave that up to the court.
And Judge, I guess I would, again, I don't want to argue the case here, but, you know, we take issue, I guess, with a lot of the arguments being raised here. And I know this is a status conference, so I'm not going to respond, but I think the court is well aware that it's our position that the court should be continued and should be increased. And we'll address that in due course.
Okay, I think realistically, it's going to be about 90 days before I can get a date based on the rest of my docket. And I don't think that's an unreasonable period of time. Mr. Jaskowski, how much time do you think we need to set aside for the hearing in this case?
I would think at least a half a day, Your Honor.
Mr. Gurmurthy?
I'd agree with that, half a day, and then over the next 90-day period time frame, we could do depositions and treat that as a discovery period.
Okay. Okay, so I'll set it for a half a day evidentiary hearing on the issue of support at about 90 days out. I will ask counsel 7 days prior to that hearing to submit just, you know, short trial briefs. I don't need, you know, full recitation of facts or anything like that, but just kind of a summary of your legal positions and what you're going to be asking the court to do at that hearing, just so I have a heads up as to what each side's legal position is and the relief that you're going to be asking for at the hearing. And again, just submit that 7 days prior to the hearing. just a couple pages. Again, I don't need counsel to be exhaustive on that, but just something so that I have a working idea of where we're going on that date. And then the court will order that discovery to remain open. Mr. Grimurthy, any other scheduling matters I could address for your side today?
I don't believe so, Judge.
Mr. Jaskowski.
No, thank you, Your Honor.
Okay, so the court will send out notice of the date and time of that hearing. And we'll go from there. That's all I have. Thank you. I'll put what we discussed into an order today as well, and all parties are free to disconnect on this file.
Thank you, Your Honor.
Thank you, Judge.
Okay, Mr. Leonardson and Mr. Thompson, if I could have each of you unmute, please. Okay, great. We're on the record now in Coppernoll versus Patrocino, case number 2311369. The record should reflect both counsel are present today by Zoom video. This is set for a status conference, and Mr. Thompson, on behalf of plaintiff, can you tell me where things are at with this case and what we need to do for scheduling going forward from your standpoint?
Yes, I'd earlier advised the court I was going to file a motion. As I looked into it, all the relief I was requesting required factual determination, so I ended up not filing that motion. I had another settlement discussion with Mr. Leonardson the other day. I don't know if we're in a position yet where we can agree to list the property for sale. That's a possibility. It's a possibility this case will resolve by settlement, but if not, it probably require the court to make factual findings about the disposition and then the parties' claims to sort of what their equitable interests are in the property.
Okay, how much more time do you want to have to try and resolve it before the court sets it for a hearing?
I think it can be set for a hearing, you know, knowing that the court is scheduling out into February. I wouldn't have any objection to that from our perspective.
Okay, thank you. Mr. Leonardson?
That seems to be agreeable. My client would prefer keeping the property if possible. There's been an offer by her of refi with $10,000 to the other party that I believe is still on the table. We're prepared to present the numbers to show that there's been a severe inequity as far as 50-50 ownership, but we would like some additional time to try to resolve it.
Okay. Mr. Thompson, is a half a day enough to take whatever proofs we need to take?
I think so, and I guess I'd ask Mr. Leonardson to either maybe repeat that offer on the record or maybe communicate with me after this conference. He just said the number at 10,000, which wasn't the same number last time we talked, and I just want to make sure we're on the same page with that. Mr. Leonardson, what did you say your client had an offer?
I talked to her yesterday. She originally made a counteroffer of $10,000 on a subject to a refinance. I believe that she's prepared to deal with that number so that she can keep the property. It seems to be more than fair based on the numbers I have. I would be glad to meet with opposing counsel and go over my numbers to show that it's a fair and equitable settlement.
All right, thank you for repeating that. We can continue to discuss that off air, so to speak. Thank you, sir.
Okay, so what the court's going to do is set this for a half a day evidentiary hearing about 90 days out. I will set it for a final status conference on the motion day immediately prior to that evidentiary hearing. If the parties are able to settle prior to that, then just notify the court and we can take all those dates down. But otherwise, that's how we'll proceed. And then I'll just ask counsel to submit short trial briefs 7 days prior to the evidentiary hearing if we get to that point. And we'll go from there. I will put all of that into an order and send that out to the parties along with the date of the evidentiary hearing and the final status conference. Mr. Thompson, on behalf of plaintiff, anything else I can address for your side today?
No, Your Honor, thank you.
Mr. Leonardson, anything else I can address for your side today?
No, thank you, Your Honor.
Okay, and I see Ms. Patricino just joined in a little bit late here. Ms. Patricino, just contact Mr. Leonardson if you have any questions about what we discussed today. That's all I have for the record. All parties are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Mr. Haas, are you able to hear me okay?
Yes, I can.
Okay. Ms. Koch, are you there?
Yes,
Okay, we're on the record now in, let's see, People versus Haas. This is case number 221113. Mr. Haas is connected today by video from the Michigan Department of Corrections. We also have Ms. Koch present. This is set for a status conference, and Ms. Koch, your motion for entry of an order of forfeiture. And so Ms. Koch, anything that you wanted to state for the record in support of your motion today?
yeah, no, I think we included everything, the fact that there's been a plea and we've provided the order we'd asked the court to sign today. Thank you.
Can you repeat that a little bit slower? Your voice is a little fuzzy there and I couldn't quite hear what you said.
Your Honor, when he filed the objection to the forfeiture, there had not been a plea. There has now been a plea, actually a fairly favorable plea, but he did enter a plea. We submitted the order. We'd asked the court to sign it today. Thank you.
Okay, Mr. Haas, is there anything you wanted to say regarding this matter?
I guess I just don't understand how my plea has anything to do with the money that was taken that day. The money in my pocket had nothing to do with drug sales. So I guess that's all I have to say.
Ms. Koch, can you state your legal position for the forfeiture?
Your Honor, there was actually in the car lots of different drugs. Mr. Stiles indicated that, or I'm sorry, Mr. Haas indicated that some of the drugs were his. They were right near him in location. They were also, he had money on him. It wasn't a significant amount of money, but he had no other indication of where he would have gotten that money at all.
All right, and so what's the statutory basis for being able to retain that money based on his conviction, I think is what his question is.
That the money was found in very close proximity to the drugs that he had on him, which I believe is the statutory requirement.
All right, Mr. Haas, did you have any other questions?
I mean, the money was in my pocket. They found the drugs underneath the front seat of someone else's vehicle. I don't see that being in proximity, but and the drugs had nothing to do with drug sales. I wasn't charged with drug sales. I was charged with possession. So I don't understand why it was taken, and it wasn't even taken from me then when I was arrested on the side of the road. They actually waited until they put the money on the booking table, which it should have went right in my account at that point. And that's when they decided to take it from me, but I don't.
Okay, thank you. Ms. Koch, anything further that you wanted to state?
No, I don't have anything further. Thank you.
All right, I did have a chance to review the forfeiture statute. I've also had a chance to review the facts of this case. Mr. Haas, I understand what your position is, and I get it, I mean, from a practical standpoint, but after reviewing the statute, even in light of what you've had to say, Mr. Haas, I think the statute does allow for forfeiture in this case. And so I think the Ms. Koch is entitled to her judgment based on the language of the statute and the facts as they are presented here. So the court will sign that judgment. Ms. Haas, is there, or Ms. Koch, is there anything further that we need to address from your side today?
No, thank you, Your Honor.
Mr. Haas, was there anything further you wanted to state on this matter?
No, Your Honor.
Okay. All right. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.
You still have the traps versus traps matters that for 215?
I do.
See anybody else. The court calls Krebs versus Krebs. This is case number 2311452. This matter was set for a status conference today. That notice was mailed out back on October 12th. In the interim, it looks like Mr. Blumberg was retained by plaintiff Ms. Krebs. However, that was after this notice was sent out. So I'm assuming Mr. Blumberg did not get notice of the hearing today, but certainly both the parties did. No one has appeared. It was set for 2:15. It's now 2:20. So the court will set it for one further status conference. If neither side appears at that time, then the court will dismiss the case for no progress.
We just give a call out, Judge, because we are in a different courtroom today.
Anybody here on the correct case?
No, yes, Judge.
Okay, we've got somebody connected on a Google Pixel 8 device. And then we have someone also connected under Karen Barnes. Both of you are going to need to go into your Zoom app and turn on your audio. And then, okay, Ms. Barnes, if you can unmute, please.
Okay.
Thank you. All right. And you're Karen Barnes, is that correct?
Yes, sir.
Okay. Can you see the other individual on your screen under the Google? Is that Mr. Barnes?
Yes.
Okay. Yeah, so Mr. Barnes, if you go into your Google app, there's a button that you can press to connect your audio. Ms. Barnes, I know this is a divorce case. I don't know, are you still kind of on speaking terms with Mr. Barnes? Is there any way that you can call him and see if you can help him? Oh,
Yeah,
wait.
Did he get it?
No, I thought it was for a second there, but it isn't. It looks like you guys are ready to move forward today. I just don't want to, I don't want to have to this, if it's just a matter of getting him connected.
So he's having trouble with his audio, is that it?
Yeah, it looks like he looks like he doesn't know how to connect the audio on his Zoom app.
Mine just came up to press a button. Hold on. Let me try calling him, sir.
Oh, folks, we're on the record right now, so if you can be as quiet as possible.
Hello?
Okay, the judge asked me to call you. You're having trouble with your audio?
Yeah, I don't know where to turn the mute microphone on. I'll look for it.
Okay, because mine, it just came up. Oh, he hung up. He says he can't find the microphone. Oh, here he goes. It looks like he got it.
Yep, we got it. Okay. Mr. Barnes, are you there?
Oh, he's muted.
Mr. Barnes, are you able to hear me?
Oh, he's calling me back. Hold on. I'm on the video thing right now. All right, bye. It wasn't him.
Okay.
He just. What is he having so much trouble with? I cannot have this postponed again if we can help it.
Yeah, no, I totally understand. If you want, he can just call in without messing with the.
You want me to tell him that?
Yeah, if you want to.
All right.
You can just choose when he calls in on the Zoom, just have him choose the phone option.
Hope he doesn't hang up on me again here.
Yeah, I can hear both of you.
Okay, we can't hear you. So the judge said, if you want, you can just do it through audio and not video.
Ms. Barnes, if you want to just leave
Hold
him
on.
on speaker on your phone, then I can just do it
Yeah,
this
if you
way.
stay on my phone, he said he can do it this way too, as long as he can hear you.
Okay.
Can you hear him?
I can, yep.
Okay.
All right, I'm just gonna try and make sure he can hear me. Mr. Barnes, can you hear me?
Yes, I can.
Okay, great. So we're on the record in Barnes versus Barnes. This is case number 2311409. We have both parties connected. And this is the date set for entry of a judgment of divorce. And Ms. Barnes, is that how you want to proceed today?
Yes, sir.
And Mr. Barnes, did you want to proceed with finalizing the divorce today?
Yes, please.
Okay. I'm going to have both of you raise your right hands. Mr. Barnes, tell me when your right hand is raised.
It is.
Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes.
Thank you. You can both lower your hands. Mr. Barnes, just let me know if you're not able to hear any of the questions that I'm asking you, okay?
Okay, I can hear you.
Mr. Barnes, you filed a complaint for divorce and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, that's true.
Does that remain true today?
Yes,
Under the judgment of divorce, you would not receive any spousal support or alimony. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
yes,
And is it true that you and Ms. Barnes have divided up all the assets and debts of the marriage?
yes,
Okay, Ms. Barnes, have you heard the questions I asked Mr. Barnes?
Yes,
Have you heard all of his answers?
yes,
Do you have any reason to believe that any of the answers he gave were untrue?
no, I don't.
And you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and would not be able to come back later and ask the court for that.
Yes,
Ms. Barnes, are there any children who are currently under the age of 18 that were born to or adopted by you during the marriage?
no,
Are you currently pregnant?
no,
And do you agree that all the assets and debts of the marriage have been divided up between the two of you?
yes,
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties. The court will grant the divorce. And I'll sign that document here today. Ms. Barnes, are you asking to have your last name changed?
yes, please. I had said no at the beginning, but yes, I'd like to change it.
Okay, can you spell the last name that you would like that changed to?
It's Stone, Stone.
Okay, so I'm writing that into the judgment of divorce. And because the divorce is final today, that means that your name will be legally changed from today forward. So
Okay.
just make sure that you get a copy of this judgment so that you can change your identification and other documents, okay?
Okay,
Ms. Barnes, do you have any questions at all?
no, sir.
Mr. Barnes, did you have any questions?
no, I appreciate the honorable conduct and civil conditions between us that we are separated and we are divorced, and that I hold no resentment.
Okay, all right, thank you. And Ms. Barnes, thank you for facilitating this so that we could get it taken care of. That's all I have for today. And again, if you need copies of the judgment, you can get those from the clerk's office here in Grayling.
Okay, is that something that can be mailed to me? Or do I have to pick them up? Because I live very far away.
So is it, I can call her.
Okay, our deputy chief clerk, Sarah, is going to give you a call to make arrangements for that, okay?
Okay, thank you very much. Thank you,
All
Your
right,
Honor.
Thank you. All parties on this case are free to disconnect at this time.
Thank you.
Okay, do we have Mr. Burns?
Yes.
You can come over to this table right here, and Mr. Backlund, are you here on behalf of Mr. Nish?
Yes, I am, Your Honor.
Okay, you guys can come to that table. If there's anybody taping this, you're not allowed to tape record here in the courtroom, so anybody who has any devices recording right now, I'm gonna ask you to turn those off. If anybody wants a record of this, they can get a transcript later on if anybody would like to have a record later. Okay, we are on the record now in Burns versus Nish. This is case number 2311430. The record should reflect we have both parties present. Mr. Burns is here. Mr. Nish is present with his counsel, Mr. Backlund. And we are set for a hearing on an alleged PPO violation. Mr. Burns, are you proceeding on your own here?
No, sir, I would like to make a statement to the
Oh,
court.
sure.
Oh, yes, sir. Your Honor. Sir.
Sure.
The Office of the Prosecuting Attorney is responsible for prosecuting all criminal and state law violations within this county, as established by the Michigan Constitution. I have visited this courthouse on multiple occasions in the weeks leading up to this matter, and I am now concerned about receiving a fair trial. As the victim, I have the right to be represented by a fair and impartial prosecuting attorney. I am surprised that this issue has not been addressed yet. I have followed all instructions given to me by the law and your clerks and have done my due diligence. There has been an obvious mishandling of this legal matter, and I demand my right to a fair trial. Michigan Constitution recognizes the importance of providing crime victims with the rights that they deserve. They have the right to be treated with the utmost fairness, respect, dignity, and privacy. But additionally, they have the right to consult with the prosecuting attorney, ensuring their voices are heard and their interests are protected. I'm almost done.
That's okay. Take your time.
I have been a victim for 21 years. I know we're going for the PPO order. I understand law. I have not received any communication from our prosecuting attorney to this day, and I had to find out on my own what steps to take. I think the failure of communication from my prosecuting attorney is no mistake. It is important to note there is a conflict of interest due to the lineage of the prosecuting attorney's daughter. Moreover, we suspect that the current prosecuting attorney may have contacted the abuser and the violator of the PPO instead of reaching out to us as she should have. I urge you to consider these facts and take appropriate action. I would like to request legal representation for prosecuting Michael Edwards. It seems both parties will then have legal representation, and I would recommend that the Michigan Penal Code under 50.277A, malicious destruction of property, and make sure that be included in the PPO order. I encourage you to take the necessary steps to ensure the evidence is properly presented and given due consideration. Thank you, Your Honor.
Thank you. Ms. Cope, did you want to address that?
Yes, I can address that briefly.
All right, let me just state for the record that this is Ms. Cope, the prosecuting attorney for Crawford County. Go ahead. Yes.
I have not been appointed on this case. Procedurally, what happens is the court will appoint me at this hearing. We will then get the file. I have very limited knowledge of this file. I did speak to the clerk today to see if we were going to be appointed on it. She indicated she would let me know if we were going to be appointed. I have heard rumors about it, but I haven't spoke to.
Hold on. Okay.
I have
Nobody
not.
interrupted. Mr. Burns.
Sorry, sir.
Just gonna have to.
Yes, sir.
And you're not part of this case.
Yes, sir.
I have not spoke to Jeffrey Nish in probably 8 or 9 years. In fact, I recently prosecuted him. I did not come off of that case. I do not believe I have a conflict. If we are appointed, I will handle it. And if we have to get a different prosecutor, I don't know if that's allowed. What I do is I file a petition with the Attorney General's office, which is fine. I certainly can do that if the court wants me to. I don't have any problem with doing that. But then they assign it, and there's a process that we go to. I just don't know if they do it for PPOs because we've never done one. They do it for criminal cases. And had I felt that I could not prosecute Mr. Nish or my office couldn't, I would have done that in a recent criminal issue. I did not. So I feel fine going forward with it, but I don't have any information. I have not been given the petition, or I have no information about this. I've had 2 people reach out and contact me about this, not Mr. Nish himself, because as I said, I haven't spoken to him. I told them that I didn't want to talk to them about the case. Generally speaking, my office is assigned to petitioners if there's a violation hearing. And I didn't have any further conversation regarding this. So I actually don't even know the facts of this case at all.
Okay, 1 second. We'll
Yes,
get
sir.
back to you.
Yeah, I don't know. I'm sorry.
Yeah, I gotta give everybody a
Yes,
chance to
sir.
be heard.
Yes, sir.
So, Mr. Backlund, do you take any position on this?
All I'm prepared to respond to is what is in the motion for show cause. I wasn't familiar with Mr. Burns' position about the prosecutorial conduct in this matter. I haven't spoken with Ms. Koch, so the statements made by Mr. Burns and Ms. Koch are to me. I don't have a position on the matter in that regard.
Okay, yes, yes, Your Honor. In my statement, I told you I had been down here for weeks, multiple times. I had been called a victim by the sergeant of the police. And I have gotten a hold of your clerk and other clerks multiple times. And 3 days ago, I was with your clerk, too. Very good clerk, very good clerk. And she did say, I asked that my wife didn't have to appear here because of, of the history, that we've been through. And if she could write a statement, and your clerk said no, that she'd be, cross-examination or something by the witness. And they knew by an envelope I got that this was done. The least I'm giving this, the 4th, but I had been here and she had told me 2 days before the 4th. I thought it was just going to be me, you, and Jeff, and I was fine with that. Do you know what I'm saying?
I guess I don't.
All right. So your clerks had told me that I was a victim. Well, in the Constitution, it says that all victims of all civil crimes, even that's prosecuting. But the thing of this is 21 years. There's been and I don't want to bring it up because we are on the PPO order, right?
Correct.
Yes. And but I've been a victim of mortgage fraud. I got in my statements of him breaking into my house. For the police. I have all these things I am here for the PPO order, Your Honor. But the clerks and your staff and the police knew I was a victim for weeks and never once was contacted by her or anybody in her office.
Okay, so you're bringing a lot of issues up here.
I'm sorry.
Which is fine. But one thing that everybody needs to understand is I'm looking at this. I know you've got a lot of history.
Yes.
But I have to go by what's in front of me, and that is an alleged violation of this personal protection order. And so you're saying that Mr. Nish violated that.
Yes, sir.
Mr. Nish has a right to hearing.
Yes,
and
sir.
for the court to decide whether he violated that or not.
And I just want it to be fair.
So of course, but when you're talking about victim, I understand you may feel that you're a victim,
Yes.
but right now the court hasn't made any decisions about whether he did
Right.
violate the order.
But I verbalized
So,
to you.
let me finish. Okay.
Yes, sir.
I listened to you.
Yes, sir.
So listen to me. That's all right. I know this is a big issue for you. So right now, as it sits, nobody's found Mr. Dish guilty of violating his personal protection.
I agree.
And that's why we have a hearing. So,
Yes.
so I understand you feel like you're a victim, but as far as it goes with this personal protection order and this alleged violation, because Mr. Dish hasn't been found guilty of violating the order yet, you're not a victim at this point.
But I wasn't a victim of all the other things that.
Again, I'm just dealing with this.
All right, yes,
right?
yes, Ron, I'm gonna
This
be
is what's-
quiet and let me take charge.
All those other things, let me finish. All those other issues are
Right.
not in front of me.
All right.
This is what's in front of me, and you're saying let me finish, okay?
Yes.
You're saying he violated it. He's gonna say he didn't violate it. So then we have a hearing.
Right.
And I take evidence from both sides, and then I decide whether or not he did violate it based on the
Yes, Your
evidence.
Honor.
And whatever's gone on between you guys for all those years,
Right.
this is what matters right now. So let's get to what we're really
Yes,
talking about, because
Your
I wanted to make sure you kind of understand the way I'm.
Yes, Your Honor, I do. You explained very well.
So what is going to happen now is you're telling me that you would like to be represented
Yes.
in this.
Also.
Okay.
Sorry, I'm his wife and
I get it.
All right,
But right
let's
now,
all be quiet.
hold on. You guys see this bar right there that goes across? The people on that far side of the bar are here to watch what's happening. The people that are on this side of the bar are here to talk and be on the record. So if you're on that side of the bar, there shouldn't be any input. And again, if anybody's recording right now, there shouldn't be any recording. If I find out that anybody's been recording during this after I explicitly said you can't do that, if you want a transcript, you're more than welcome to get a transcript later. You're going to be subject to the contempt powers of the court. So I'm giving you a warning right now.
Yes, sir.
Anybody who's on that side of the bar, You're here to watch and here to observe. Everybody on this side of the bar is here to talk. So let's get back down to what we
I
were
trust
talking.
you, Your Honor.
So what you're saying to me is, you would like to be represented by the prosecutor's office.
Yes, sir.
Or a prosecutor's office to present your case.
Yes, sir.
As to whether or not this violation.
Because I did go to law school, Your Honor.
Sure, okay. So, because that's your request, and I think that would be fair, Mr. Nish is represented by counsel, so I think it's fair that you should be represented by
Thank
counsel.
you.
So I am gonna order that the prosecutor's office represent you. Now, let's move on to the second issue.
Yes.
Because I heard you loud and clear. You don't feel that Ms. Koch is gonna properly represent.
No, Your Honor.
So I'm gonna tell you right now, as the judge in the case.
Yes.
All I can do is require the prosecutor's office to represent you. Whether there's a conflict between the two of you is something that you guys have to work out. I can't.
Okay. Can I bring up one thing?
Sure.
That I've already felt that there was a leak, because of the family matter, and that the evidence that I have so gainfully gained will be leaked also.
Yeah, I understand your concerns, and that's not anything that I can do about at this point.
Okay, I trust you, Your Honor.
The other thing that you can do, is you can hire your own attorney to represent you too, if you wanted to do that. If you didn't feel like Ms. Koch was going to adequately represent you, or, and I don't know, it sounds like Ms. Koch may refer this to the Attorney General's office to see if they'll take the case.
I would prefer that.
And again, that's something that's outside the scope, because
yes, sir,
I'm the judge. I have to be impartial. I have to give both sides equal opportunity.
Yes, sir. That's right.
So I can't get involved in either side.
Yes,
and
sir.
help either side.
Yes, Your Honor.
So that's what I'm trying to do.
Yes, Your Honor.
As part of my job, because I'm ultimately going to have to make the decision. So, Ms. Koch, is there anything that do you want me to do a written order appointing you to the case so that?
Nope, that's fine. I can talk to Ms. Butler, get a copy of the file and be prepared, unless the court wants to take a short adjournment. The court wants to do it today, but I haven't reviewed any of the stuff, and it sounds like Mr. Burns has a lot of information.
I think, in fairness, Mr. Burns, I think there needs to be a little more preparation done.
Thank you.
So I'm going to adjourn the hearing for today. So Mr. Backlund, I guess, just continue to communicate with Ms. Koch. I'm going to set this out 30 days for a hearing. I'm going to set it for a half a day hearing, because it sounds like we may have a fair amount of evidence potentially. If either side, Mr. Backlund or Ms. Koch, if you determine that you need more time for the hearing itself, or if you need more preparation time, just let the court know and we can make accommodation for that.
Certainly, thanks.
Thank you, sir. I have one last question, since I'm naive to this situation.
I think you're doing an excellent job.
All right, thank you, Your Honor. Now, if I give I know both sides I have 3 packets, like as instructed by your clerk for whatever. But when I give them 3 packets, are you following me? I don't want to give them a month ahead of time when they give me nothing, and then they can work on rebutting my facts. Do you understand what I'm saying, Your Honor?
Yep.
So can I maintain until I get with counsel, my evidence?
Yeah, I'm not forcing you to turn over anything.
All right,
today.
thank you, Your Honor.
But there are rules, and the lawyers will.
I'll wait by all rules.
Yeah, that where each side has to give the other side.
That's fine.
Because the object is so that nobody's surprised by anything at the day of the hearing. Everybody's been able to see what each side has, so that each side can prepare.
I just want to say I thank you for your job and what you're doing. And no matter how this would have turned out, I wanted you as my judge because I think you're fair. And that's all I asked for in this trial. So fair here.
Thank you. Appreciate that. Okay, so Mr. Backlund, anything further for the record?
Nothing further.
Ms. Koch, anything further?
No, thank you.
Okay, so Mr. Backlund, I'm just gonna have you and your client exit the courtroom. I just don't want there to be any issues. So if you folks can just wait here for a couple minutes, let Mr. Backlund and his client leave, and then everybody will go.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Next hearing is set for 5. We'll take a short recess.
Is Mr. Poppin today? Fun work, apparently.
I'll take care of it. Mr. Gunn, I'll have you step out here for me, please.
Uh-oh. I don't sound good.
So there was,
Okay, Mr. Vernon, if you can unmute, please, on your side there.
I did,
Okay.
let you know that.
All right, we're on the record now in Schultz versus Clay. This is case number 2211257. If I could have counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Joshua Williams, PA3410, appearing on behalf of plaintiffs.
And we're on behalf of the defendants, am I right?
Okay, we're set for a status conference today, but we also have noticed up a motion for summary disposition. And Mr. Vernon, you filed that motion. I had a chance to review your motion and the supporting documents. So is there anything that you wanted to say for purposes of oral argument today?
So what let's start out with, Your Honor, is pursuant to MCR 2.116 G4, the non-moving party has not filed a response to the motion, and the court rules pretty clear that they can't rest upon the mere allegations or the denials in their pleadings, but must by affidavit or otherwise provided specific facts, show specific facts that there is a genuine issue for trial. And it states that if the adverse party does not so respond, judgment, if appropriate, shall be entered against him. So I would simply state and ask the court that because the plaintiffs did not file a response, that they are not challenging the allegation or the proofs and the facts that we set forth in our motion, judgment should enter on behalf of the defendants, and this matter should be dismissed.
All right, thank you. Mr. Williams?
Just as it relates to the filing of the response to the motion, unless the court did not receive it, we did file a response to Your Honors. It was through fax. It was not in through the registered mail, but that was filed Monday, I believe.
Yeah, I mean, I guess I got something that's titled as a response, but all it is you know, admissions or denials. There's really no law or argument in there.
And I understand that. And as far as the allegations in the motion for summary disposition, their basis is on fact, but as a matter of law, they didn't support any of their allegations through as a matter of law that there would be no way that this claim could proceed. And I believe that there's question of fact, as this matter is, still right for a jury, because these are all questions of fact for the trier of fact.
All right, Mr. Vernon?
We received no response. I'm not sure to what the party is referring, but I didn't receive anything. Does the court have a proof of service? Because I don't have any document. And we checked on the register of action this morning to confirm whether something was filed or not, and it didn't appear on the register of action that anything had been entered as received by the court.
Well, the proof of service says, I, Joshua Williams, certify on December 4th, a copy of the foregoing document was filed with the Crawford County Circuit Court. So I don't see where it was served on you, Mr. Vernon. Did you send this to Mr. Vernon, Mr. Williams?
We sent it to their fax, the whatever fax was on their site. At the same time, it was sent to the court, but I didn't confirm.
We have multiple staff that check the fax machine every day and use it every day. Nothing came through, and I never saw it. So I would ask that that's one, not proper service, and two, to suggest that this is a question of fact. The purpose of the motions, either by C8 or through C10, are based on the allegations they set forth. So we're assuming that the facts that they laid out in their allegations are true. So I don't know how they can argue it's a question of fact. These are their facts we're using.
The count one with regards to trespass, they identify in their complaint, and I identify in the motion that they cite in paragraphs 15 and 17 and paragraph 18, and the limitations of the Trespassery Act is that my client's pulled up his driveway and had a conversation with his client. The case law I cited in the motion identified that that type of an encounter is completely justified pursuant to, Bread versus Alexandria and McKee versus Gretz. The simple using of the driveway to enter and investigate as to whether they can have a conversation is an appropriate entry. It's not a trespass. So we make that argument, and I think that that's, pretty straightforward and pretty clear that that's the only trespass they discuss. Count two with regard to nuisance of fact or nuisance in fact, case law is pretty clear on that. In order to recover for a nuisance in fact, there has to be substantial damages. They allege no damages. Well, that's not true. They allege substantial damages, but in their allegations, they set forth no proofs of allegations. And according to them, again, in their allegations, the only nuisance was the entry onto the property, which they described as simply pulling up the driveway and having a conversation. That results in no damages, let alone substantial damages. So nuisance, in fact, they failed on the element on that one. So they should, that should be dismissed. And then on count three, the quiet title, which we identified, really a claim for an easement. The court is in receipt of the admissions that were made by the defendant or the plaintiffs in this matter that were never answered. So the court presumes them admitted. We in fact took the extra step of giving them notice that it was our intention to rely on them as admitted, and they still have taken no action with regard to those. So I see no reason why the court wouldn't consider them admitted. They admit that they have only used the road since the Ravenna Road, the road in question, since 2021. So their claim of a prescriptive easement fails because they haven't used it for the appropriate period of time. And they admit that they have alternate means of ingress and egress. So any issues with regards to a easement by necessity would fail because, again, easement by necessity would require no other means of ingress or egress. So all of these counts, based on either their allegations and their facts as support or the admissions that they made, result in no genuine issues of fact that need to be decided. And those issues all resolve in favor of the defendants. We would ask the court to dismiss with prejudice.
All right, thank you. Mr. Williams?
In response to even taking into account, everything from defense's arguments, as it relates to the trespass, that issue, even through defendant's own admissions, it is a question of fact. They're not denying that there was ever a trespass. It's the fact of the substantial damages or any relation to damages or a remedy to that. But we'll concede that the third and final claim relating to the quiet title action through request for admissions, that those were deemed admitted. But as it relates to the trespass, that's still a question of fact, which for the trier of fact.
Okay, all right. I did have a chance to.
If I may respond.
Sure.
When he says that the issue of damages is the trespass, he's misunderstanding. Damages is an issue as it relates to nuisance in fact, not trespass. The trespass isn't a question of fact. We're relying on their facts. These are their allegations. And they don't sustain a sufficient prima facie case because of the law that states entering onto the property for the mere purpose of soliciting or seeking permission to have a conversation is not a trespass. So again, I think he's confused there. But I wanted to clarify that the issue with regard to damages is the nuisance in fact issue, not the trespass damages. Because there are no damages related to either one.
Okay, thank you. This was number 5.
Unless it's in the court file, Judge, I don't have it. The last entry I have in my case on this
Service.
was on 11/9, set case on calendar for today.
All right, so I had a chance to review the file prior to today's hearing, as well as the submissions of the parties. First of all, just simply from a procedural standpoint, the defendants filed a proper motion for summary disposition. They made allegations of fact. They cited the court rules that they were basing their motion on. Mr. Vernon cited the law that he believed that supported his motion. And then Mr. Vernon also alleged facts that were admitted by the plaintiffs through failure to respond to discovery requests. And so, you know, from a procedural standpoint, the defendant's motion was properly filed, properly noticed, you know, and supported by documentation as well as statements of fact and law. Mr. Williams, your response really is, number one, it wasn't properly filed with the court. It wasn't properly served on the defendants. So it's really not, I mean, I received, I guess, a fax copy of it at my office, but that's much different than filing it with the court and properly serving it. Even if it was properly filed and served, it's really not a response at all. I mean, it's basically just blanket admissions or blanket denials or taking no position on the allegations of the defendant. And on a motion for summary disposition, to oppose a motion for summary disposition, the party needs to cite facts and law. They need to provide documentation to the court contradicting the position of the moving party. And so, you know, it's completely inadequate, even if it was properly filed, it's completely inadequate as a response to a motion for summary disposition. It doesn't cite any facts, it doesn't cite any law, it doesn't cite any court rules. And your argument today hasn't really enlightened the court much, if at all, as to your legal position on the motion. And, you know, it's just, it's completely inadequate as a response. And it's not up to the court to figure out what a party's argument is. A party has to raise the argument with the court and support that. So frankly, I'm not even going to consider the response on its merits because there isn't anything there for the court really to consider. And I'm not going to search and research Mr. Vernon's motion to see if it's well supported or not. Mr. Williams, that's your job to do and your job to provide to the court with the results of that. And so I think from a procedural standpoint, it's completely inadequate. And so the court will grant the defendant's motion on that basis alone. If the court were to do plaintiff's counsel's job and look at the motion on its merits and look at whether it's properly placed or not, I do think Mr. Vernon has properly cited the authority. I think he's relying on the facts as stated by the plaintiffs for his legal position that even if all those facts are true, there couldn't be a trespass, there couldn't be a nuisance here. And based on the admissions, there's no grounds for any of the relief requested by the plaintiffs. So even if the court were to look at it on its merits, the court finds that there wouldn't be any reason why summary disposition wouldn't be appropriate in favor of the defendants. So for all those reasons, the court finds, Mr. Vernon, that your motion should be granted for the reasons stated. Mr. Vernon, I'll ask that you submit a order to the court reflecting the ruling, along with an indication in that order that this closes the case and resolves all pending claims, and submit that under the 7-day rule. That's all the court has for today, and all parties are free to disconnect at this time.
Your Honor, can I clarify as to whether the court's dismissing with or without prejudice?
I think summary disposition is with prejudice. So
I want to confirm. Thank you.
yeah, okay.
Thank you, Your Honor.
Thank you. Mr. Michels, are you able to hear me okay? Counsel, if you can unmute, thank you. There. Mr. Michels, are you able to hear me now?
Yes, sir.
Okay, thank you. We're on the record in People versus Brent Michelle's case number 224992. And we have Mr. Michelle's counsel, Jennifer Mead, present by Zoom video. Mr. Michelle's is also present by video. Ms. Mead, how did you want to proceed today? I believe this is your motion to withdraw, is that correct?
It is, Your Honor. It's my motion to withdraw as appellate counsel, and I apologize. I put the wrong date in my calendar as the due date for his motion, and I do not want Mr. Michels to not be able to take advantage of his appellate rights. So I am asking that the court allow me to withdraw as appellate counsel, have new appellate counsel appointed to represent Mr. Michels, and to restart his appellate timeframe, so that new counsel would have the 6 months to file on his behalf.
Okay, thank you. Mr. Michels, did you have any input in this matter?
Just I'd like to keep moving forward with our progress with everything going on.
Okay. All right. The court finds it would be appropriate to enter that order. And so, Ms. Beats, can you submit an order to the court granting your motion? And then just so that we have it for as a matter of record in the file, indicating that as you said, that Mr. Michel's time for perfecting appeal would not be affected by the change in counsel.
So a couple hours ago, I emailed a proposed order. And I emailed over a proposed order to I believe your clerk that would restore Mr. Michel's appellate rights pursuant to MCR 6.428, and to remove me as appellate counsel and appoint substitute appellate counsel. So I've already emailed that to, and I'm looking to see who I sent it to, Ms. O'Rourke and Ms. Hilliker.
Okay. So I'm in, I have a 3-county circuit, and I'm not where my office is today. I'm in a different county. So I don't have that right now, but I'll sign that tomorrow morning when I get back to my office in Otsego County.
Do you want me to send it to where you're at?
No, because frankly, I got a docket today, so I probably wouldn't get to it till tomorrow morning anyway. So I can sign it in the morning.
Okay.
Okay, very good. Mr. Michels, did you have any questions at all?
No, sir.
Okay. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you, Judge.
Thank you.
Okay, that concludes the court's docket for today. The court will be in recess until 9 a.m. tomorrow.